Hey everybody, this is the Law and Crime Network, and this is the afternoon session, and this is Michael Bryant. And why is Michael speaking to us in third person? I'm not sure why he's doing that, but he's glad you're here. A lot going on today as we kind of prep for a number of matters that we're launching maybe as late as this afternoon, first thing tomorrow. Not one, not two, yet two. Two brand new trials beginning. The first is a case out of Tennessee, which they are in jury selection right now. That is the case against Sean Foley. We're going to get into that in some detail, tell you a little bit more about that. But basically, this guy is charged with killing another man who he thought was molesting his 25-year-old girlfriend. Again, that is out of Tennessee. The other case that is currently in jury selection is Florida versus Michael Drejka. This is the case in which the victim, McGlockton, his girlfriend parked a car in a handicapped parking spot outside a convenience store. That is not something Michael Drejka liked. He confronted the woman in the car. The boyfriend, Marquise, came out of the convenience store, pushed Mr. Drejka down. Mr. Drejka responded with a gun, firing, killing Marquise McGlockton. So we have a special guest to start off our kind of preparatory coverage of this case. I have with me, and happy to say so, Michele Rayner-Goolsby. Michele, thank you, first of all, for joining me. I appreciate it.
Thank you for having me. I'm
you
really
bet.
excited to be here.
Michele is not only a criminal defense attorney, but specifically, as we talk about this case, she is the victim's family's attorney. And that would include the girlfriend, Brittany Jacobs, correct? Is that right?
No, I actually work with Attorney Benjamin Crump on that case, but Attorney Crump actually represents Marquise's girlfriend. I represent his parents,
okay.
And Michael McGlockton. But it's kind of like a family affair. We all work together on this case.
Yeah, so let's talk about this. I gave sort of the basic details. Tell me what your take is, what the family's take is on what happened that day.
So on July 19th, as we're all aware, Marquise McGlockton had ran into the Circle A store. He was getting snacks. This is something that him and his girlfriend did all the time. In fact, I'm from Clearwater, right? So I am very familiar with this store. He ran in, individuals saw Michael Drejka approach the vehicle, so much so that there was one man that kind of stuck his head into the store like, something's going on, something's happening, right? And then Marquise comes out there. He kind of sees Drejka almost up on the vehicle, up on Brittany. And I think it's important to note that Marquise went into the store with his son, but there were two other children in the vehicle. So he pushes him away. Drejka falls to the ground. You see Marquise literally at maximum retreat, backing up against the car, and he gets shot, and he was shot in his side. So really, what was pivotal about this case is that it took 25 days for Michael Drejka to get arrested because the sheriff, Bob Galtieri, who's also a lawyer, by the way, said that he believed that stand your ground was appropriate and he could not arrest Michael Drejka under that statute. And then he referred it out to the state attorney's office, where the state attorney made a charging decision of manslaughter.
So let's talk about that, because that's unusual procedurally. Florida is a stand your ground state. We've talked about it many times here in covering different cases here on the Law and Crime Network. Basically, you have no duty to retreat, but you have to have some sort of threat that you're fighting off. In this case, what do you think happened, other than handing off the case from one law enforcement agency to another? What might have happened to change the position that stand your ground did not protect Mr. Drejka?
Well, I think the thing that happened, there was a video, right? So we've seen the video. It's been played 1,000 times. And I think what the prosecutors did, and to be frank, I deal with prosecutors in that office all the time on a daily basis. I think the prosecutors that were assigned, and some of their best prosecutors were assigned to this case, they looked at the video. They looked at the interview that Michael Drejka had after this incident on the very same day. And it's very clear that, and I'm watching the video, that Marquise pushes him, he backs up, and then he gets shot. And it's very clear that it was not reasonable for Michael Drejka to say that he was in fear after the moment that Marquise backed up. And I think that they're also looking at what happened after the fact. So after the fact, there are witnesses that said that Michael Drejka was sitting on the ground, like on the stoop. He was very calm, very collective. One witness said that he actually hid to call law enforcement because he didn't know what he was going to do. That almost that Michael Drejka was a little proud. So I think when you look at the totality of the circumstances, you have a situation where the prosecutors felt that they had to charge.
You know, doing some of the research for this case, I see that there were prior incidents with Mr. Drejka. Apparently, he's got a thing about people using the handicap space when they're not officially handicapped, and I have to admit, bothers me too. I'm not shooting anybody over, but it bothers me as well. So, but he has a history of having confronted people. Also, apparently, a history of brandishing a weapon while driving in his truck in that Clearwater area. 2 incidents happening back in 2012. So, I'm sure you're aware of all of that. Let me ask you this then. All of this looked at as a whole, and the video you mentioned, and I know now that the court said they can use a slow motion version of it in trial. Why is this going to trial? I mean, clearly from your point of view, it's a done deal.
Right. So here's the thing. Obviously, the maximum that he could get under Florida statute is 30 years. So the family has been very adamant that they want him to be convicted, or, he's going to have to plead to 30 years, right? And as a criminal defense attorney, if the only offer is the maximum, well, we're going to go to trial. We're going to take our chances with the jury, and we're going to see what happens. Here's the thing, and because I do this, and I've been doing this for about 7.5 years, when you go to jury trial, there is no guarantee that the jury is going to go the way that you want it to go. I've had cases where my client was dead to rights and he was acquitted. And I have cases, not a lot, where my client was innocent, did not do it, and he was found guilty. So we're at a standstill wherein Michael Drejka, his defense attorneys are not going to have him plea out to the maximum. So we're going to trial. And I think that, I'm hoping that the jury gets it right, but you don't know. And that's why, as you and I both know, today's jury selection, and probably tomorrow and possibly Wednesday, this is the most pivotal time for any trial, because you have to get 6 individuals that can lay aside their biases, lay aside their opinions, lay aside all of those things, and make a decision based on the facts and the law.
And you mentioned six individuals because this is not a death penalty case. Florida is a little unusual in that way. Is that a good or bad thing for your case, do you think? Or for the defense case? Either case.
Either case, right. So for the defense, they only need one juror. They only need one juror to say, listen, I don't agree with that. I'm not, I don't know if I could find them guilty. The state hasn't proven their case. The state needs all 6. Obviously, if you had 12 people, that would be more people that you would have to convince to get on your side. So, it's going to be a battle for each party. It's going to be a battle for the defense. It's going to be a battle for the prosecutors, because you're going to have to convince that this jury, if you're the prosecutors, that this was unjustifiable. It wasn't reasonable at all. And if you're the defense, you're going to have to say it was self-defense. He had a reasonable fear that if he did not shoot Marquise, that his life would be in danger, great bodily harm, so much so that he possibly thought that maybe Marquise would kill him, or, I think his words in the video were that he was going to keep pummeling him or something to that extent.
Yeah, and the jury is going to have to decide if that was reasonable. Let me ask you a question germane to what you're doing here. And you mentioned the plea, and you mentioned that the family wants the max, 30 years. Was the family consulted in any plea negotiations?
Well, you know what? When you get to this phase, usually as a defense attorney here in Florida, and specifically in Pinellas County, when you have this kind of case and this kind of, let's just say it, national publicity, you as a defense attorney have to go to the state. You have to go to the prosecutors, and you have to make an offer. And as far as I know, there was no offer made by the defense. I can only speculate that's because Michael Drejka from the very beginning has been very consistent in his stance that it was justifiable and he didn't do anything wrong. He felt, and he said this in his interviews, he felt that he used stand your ground in the most appropriate way.
Let me ask you one quick question before I let you go, Michele. How's the family doing?
It's hard. This is just a part of their journey. It is one of the hardest parts of their journey. And I think that right now they're very focused on this trial, very focused on getting a conviction. It is hard because, as I don't know if you're aware, the defense has really used the opportunity for pretrial hearings to really try to paint Marquise as someone that he was not. So, to be able to have to sit through that and then have your hope for justice in the hands of 6 other people, that's a lot, and it is nerve-wracking. And so, they're doing as well as can be expected.
Yeah, now we're looking at it's been about a year and a month, so now I hope they're braced for really reliving the details of this horrible day. So I thank you, Michele, for being with me. I appreciate the insight. As you know, jury selection underway. Any insight as to where they are in that process? Do you know how it's going?
So right now, I think that they're still at Judge Ballone's questioning. And so, I've been kind of keeping up via the internet because, quite frankly, I love jury selection when I'm doing it. I don't like it when I'm watching it. And so I wasn't going to sit through it. But so they're right now at Judge Ballone's questioning. I think that they're just at the point where the prosecution's going to start doing some of their questioning. And they've already, I think, stricken maybe about 1 or 2 jurors already. And so we're there, but I don't foresee jury selection ending before Wednesday, to be honest.
Okay. Well, we will certainly keep on top of it. Michele Rayner-Goolsby, I appreciate it. The defense attorney, criminal defense attorney in Florida, and also representing Marquise McGlockton's parents. Thank you, ma'am. I appreciate it. You bet. So obviously this is going to be unfolding in the days ahead, a very unusual case because of the defense of self-defense via the stand your ground. So we'll get into that. And today we have an opportunity to kind of look back on some of the fascinating cases we've covered more recently here on Law and Crime. So get your notes from some prior trials, Rosenbaum, you remember that one, and Lindsey Parton. Get those handy. We're coming right back to the Law and Crime Network.